Good afternoon, everyone. We are here for oral argument on the Respondent's appeal of the Hearing Committee report in the matter of Bar Counsel versus LIsa Belanger. The parties may assume that the board has read the papers in this matter, and the procedure for the oral argument this afternoon will be as follows. Each party has 15 minutes for argument, inclusive of any questions that may be asked by board members. We will utilize the light system. There is a light on your table there and a light here. The light will be green for the first 14 minutes, and then at 14 minutes it will turn yellow, and then at the 15-minute deadline it will turn red, and then it will turn off. And I will be stopping any argument at the 15-minute deadline for each side to ensure a fair hearing for both parties. We will begin with the respondent, to be followed by Bar Counsel. And with that, Ms. Belanger, you may now proceed. Thank you.
Yes, please let the record reflect that board member Attorney Marsha Kazarosian and Chair Jeffrey Martin are not present here for this oral argument. And I would like to have the record reflect as to the members that are here. Would the members would like to please say their names, or should I just?
We generally don't identify ourselves, so
Oh,
you may.
well,
It's, the 15 minutes is yours.
Oh, okay. Well, you know what, that's fine. That's right. I'll give a tally at the end. Thank you. So, good day. And let me please start out by saying, with all due respect, I really hope this board has enough decency to not interrupt me while I make my statement. I mean, to say the least, I'd really like to thank the board, because you really have outdone yourselves by taking such extraordinary measures as giving me 15 minutes to present this oral argument. And you all done on my behalf, so thank you. And I'd really like to know, does this board really think that the citizens nationwide who have been calling this office cannot see through this board's antics? And it seems to me that, I can verify later, there does not seem to be a court stenographer here to take notes. And I'm hoping that the board would have good procedural mechanisms for taking audio as well. But we do have video and audio here, so if you don't, that's okay. It speaks volumes that this board's own written rules state that this is a public hearing. It's a public hearing, and obviously this board is too afraid to have their faces and names put on camera. And the record overwhelmingly establishes that the fix has been in from the very beginning with these sham disciplinary proceedings. As board member Marsha Kazarosian brought this very complaint against me, along with attorneys from the law firm of Burns and Levinson, who were co-defendants with board member Kazarosian in my 2015 federal civil racketeering action. The very basis on which this board brought this action. And it's important to note that board member Kazarosian was a defendant in that 2015 racketeering action, along with the Burns and Levinson, which Chair Jeffrey Martin is managing partner. And it's important to note that the chair of this board, Jeffrey Martin, represented those defendants as counsel in the 2000 federal civil action. The very complaint that this board incredulously went forward on. It's unfathomable. As we sit here, and I'm so glad that you're really paying attention, because I think it really says a lot, because if that is not a conflict of interest, please tell me, because I don't know. I know I went to law school about 20 years ago, and I'm hoping that you're up to date with what conflict of interest is. So, excuse me. Significantly, the very reason that board member Kazarosian filed the complaint against me for supposed wrongdoing that happened, 5 years ago, supposedly. But mind you, I brought complaints against her and many complaints in her cohorts. And this board and bar council, they did not want to do an investigation. But 5 years later, lo and behold, what does attorney Marcia Kazarosian do? She files a complaint against me. And why was that? And that was because Boston Broadside did an expose showing the financial and physical exploitation of my elderly father. Yes, that's called retaliation. Unlawful, vicious retaliation, which is against the law. Okay. So, this all boils down. This attack by the Office of Bar Counsel and the Board of Overseers solely took place because I am a whistleblower, specifically having exposed judicial and attorney unlawful and, in fact, criminal conduct. Everything that the Bar Council and Board has done, continues to do, is all about the cover-up for board member attorney Marcia Kazarosian in Burns of Levinson, the firm which Chair Jeffrey Martin is managing partner. And again, let's reiterate who did not have the fortitude to come here and look me in the eye. I say that speaks volumes. Without 7 years, the court records in which I have shown, especially in my 2015 complaint, I proved with volumes of court records backing up every allegation that I made, establishes that board member Kazarosian furthered the unlawful and heinous drugging of my father against his will for 7 years with antipsychotics. Just imagine, did you not think that that can't happen to you? Really? You must not think it can happen to you, because otherwise, I would not be over in this place. But no, it's all about the cover-up. 7 years that board member, attorney Marcia Kazarosian, because of her powerful ties with the Board of Bar Overseers and Bar Council, unlawfully, maliciously, viciously deprived me and my father, who loved me to no end, to have him not have communication of any kind with his daughter, the daughter that he put down in a durable power of attorney that was ironclad. And yes, I proved that it is an established systemic problem that durable power attorneys are routinely disregarded in the mass probate and family court system and nationwide. My father unequivocally stated in writing and stated in court, even when drugged, over and over, that he wanted to be with his loving daughter, attorney LIsa Belanger, and her family. But because I exposed board member attorney Kazarosian and her accomplices of her collusion to drug my father with antipsychotics, which, by the way, Attorney General said is against the law. But she defended that in the federal action. Everybody else, it's against the law, except when you're part of the court system, isn't it? Without a scintilla of evidence or justification, board member Kazarosian, chairperson Jeffrey Martin, and the rest of the accomplices have ruthlessly employed smear tactics, slander of the highest degree, projecting accusations of the most evil that they themselves have perpetrated. In fact, it is so reprehensible that Assistant Bar Counsel Adam LaFrance actually wrote, and mind you, signed under pains and penalties, so I'm hoping that the bar kind of applies this both ways. And from the 3-member board, put their names on a hearing report stating that I, Attorney LIsa Belanger, financially exploited my father of $85,000. How do you people go to bed at night? Do you really, is there blood in your veins? Because I'll tell you what, how interesting it is that wasn't even in the petition for bar discipline, accusing me of financial exploitation, but yet didn't even charge me with it. Really, that was so significant, wasn't it? And that claim came by 7 years later, in which the court records show that unequivocally that is wrong, more than wrong. It's fabrication and made up, which is also unlawful. The GALs, more than a half a dozen, who didn't want the case, and they all had some reason not to be part of it, in the end, there was no problem. The GAL put his name on it that nothing happened to Mr. Siegel's estate, but yet they continue to say it and put me through this hell for what? For exposing the continuous antics? There are no charges against me, and the reason why, because you know, if it's a court of law, if I were in a criminal court of law, you all know that they were fabricated. How dare you? So, evidently, $7 million wasn't enough. Excuse me. Evidently, $7 million was not enough for these reprobates. No, board member, Attorney Marsha Kazarosian, and the law firm of Burns and Levinson needed to have a sick pleasure in trying to destroy me, and I say try, no try to destroy me and my family. Unsuccessfully, I say. And why? Because I exposed them. And what is really upsetting to board member Attorney Marsha Kazarosian and the law firm of Burns and Levinson is that I exposed their racketeering ring. Yes, that is my crime. I exposed their racketeering ring. And it's all substantiated with cold, hard, factual court documents. So when Attorney LaFrance, his biggest argument for wanting to suspend my law license is based on supposedly, I have lost perspective, air quotes, and supposedly said bad things about judges. Again, let me reiterate, all backed up with volumes and mountains of court documents not he said, she said, actual court documents. I suggest that this board go back and review the recommendations and the statements made by Assistant Bar Counsel Attorney LaFrance. And please, review all the outright fabrications and misrepresentations. I have supplied unbelievable, hard, cold evidence, and yet here I sit in 2019, and you would think it was 1620, because guess what? This is no different than the 1620 witch trial. I suggest that this board go back, read those documents, and I mean, really read them this time.
Thank you, Ms. Belanger. That's your time. Thank you.
Well, excuse me,
No,
we
ma'am,
all know who should be sitting on this side of the table.
ma'am, your time has expired. Thank you very much. It's now time for Assistant Bar Counsel. Thank you very much. Thank you. You may proceed.
Good evening, members of the board. My name is Adam LaFrance, Assistant Bar Counsel assigned to the matter at hand. Bar Counsel asks that the board adopt and affirm the recommendation of the hearing committee to suspend the respondent for at least 2 years. First, because there is no error in the hearing committee's findings and conclusions. They are detailed and substantially supported by the evidence, and those grounded on credibility determinations are consistent with the facts and evidence. Second, the hearing committee's legal conclusions rest on correct application of legal standards to the established facts. The sanction recommended by the hearing committee is sustained by the record, it is supported by relevant precedent, and it is appropriate discipline under the circumstances. Finally, because the respondent has not and cannot show that she was denied due process at any point, but specifically to her grounds as to fair notice, as to a full and fair opportunity to present a defense, and as to a fair and impartial trial of facts. The respondent was clearly, and in some cases repeatedly, afforded these opportunities, and she took them or waived them. Upon receiving the petition for discipline, the respondent admitted or did not deny several factual averments. Following the pre-hearing conference, given that many of the remaining alleged facts had been previously litigated to completion, Bar Counsel filed a motion seeking an order of issue preclusion, to which the respondent responded. The hearing committee allowed Bar Counsel's motion in part, and as a result, for our purposes, there was no longer any dispute that, among other things, the respondent violated several court orders or judgments of the Essex Probate and Family Court. The respondent knowingly used false pretense to deceive a healthcare worker to gain access to her father in a secure medical facility in direct violation of a court order. The respondent thereafter, again, knowingly gained access to her father in a medical ward, again in violation of a court order. The respondent failed to pay sanctions ordered by the court for continuing to raise allegations in opposition to normally routine matters which are not based on facts, needlessly reducing her father's estate. The respondent was found in contempt for failing to pay those sanctions after the court found she was able but unwilling to do so. Between the respondent's admissions and the order on issue preclusion, most of the relevant facts were established well in advance of the hearing. The hearing itself was then essentially limited to 3 issues, narrowly focused on certain ethical rules and the facts of the respondent's behavior in the course of litigation. Namely, whether the respondent's first violation of a November 8, 2011 court order was knowing or intentional, essential to which was her state of mind. Whether a respondent continued to claim and to seek without basis a judicial declaration that a 2003 durable power of attorney was valid and controlling, notwithstanding that the court revoked all powers of attorney, including that of 2003. And whether the respondent made statements concerning the integrity of judges, either knowing the statements to be false or with reckless disregard as to their truth or falsity, essential to which again was her state of mind. In preparation for hearing, the board's rules provide for disclosure of witnesses and exhibits between the parties. The respondent failed to furnish to bar counsel and to the board the witnesses and exhibit lists as required. The respondent further declined to object to the 40 exhibits submitted by bar counsel. Consequently, the respondent waived all objections to bar counsel's exhibits and was ultimately precluded under the rules from introducing any exhibits or witnesses of her own other than her own testimony and any exhibits or witnesses she could seek to introduce at the hearing, subject to objection by bar counsel and the discretion of the committee. While the respondent alleges 3 perceived deprivations of due process as grounds for her appeal, the record unambiguously shows that she was provided every opportunity, under all relevant rules, to respond to this matter and to raise her defense. Among other things, when served a petition for discipline, and long before seeking a more definite statement of charges, the respondent filed an answer admitting or denying with particularity allegations that she subsequently sought to claim were vague. When presented with the opportunity and a deadline by which to provide a list of proposed witnesses and a list of proposed exhibits with copies, the respondent declined to do so. When presented with the opportunity and a deadline by which to object to the lists of witnesses and exhibits proposed by bar counsel, the respondent declined to do so. Just before the original hearing date, the respondent moved to continue. When provided an opportunity to appear and be heard on her motion, the respondent declined to do so, notwithstanding the hearing was continued. At hearing, when provided an opportunity to answer questions and present her defense, the respondent ultimately declined to do so. After hearing, when provided an opportunity to submit proposed findings and conclusions, despite 2 deadline extensions that she requested and received, the respondent declined to do so. As to ensuring a fair and impartial trial of facts, when the respondent was provided an opportunity to request recusal of a hearing committee member to whom she objected, the respondent made her request and her request was allowed. She made no further requests. Finally, where the respondent argues the hearing committee's admission of the opinion of Judge Burroughs infuses bias into their decision, the hearing committee's findings cited by the respondent are their own observations and their own credibility determinations. The respondent offers no substantiation to her allegation, and importantly, when the respondent had an opportunity to object to the admission of Judge Burroughs' decision, she declined to do so. Simply put, there is no merit to the respondent's claims of a lack of due process or impartiality at any point in the proceedings. While not specifically raised as grounds for appeal, the respondent touched on several factual findings suggesting they were made in error. As detailed in bar counsel's brief on appeal, the respondent's objections boil down to dissatisfaction with the hearing committee's refusal to adopt her interpretation of events. The hearing committee's determinations are not only well supported by substantial evidence, the respondent, who carries the burden of proof and affirmative defense and mitigation, declined to make any such showing. The hearing concluded abruptly on the second day of 3 upon the respondent's decision to stop cooperating. On the evidence and facts established before and at the hearing, including several matters in aggravation, bar counsel recommended a sanction of at least 2 years. Similar to the respondent, as to Rule of Professional Conduct 3.1, the attorney in matter of O'Leary received a 3-month suspension for repeatedly raising frivolous claims as part of an extended and persistent course of conduct, failing to recognize the nature of his misconduct at issue. Knowing violations of court orders, particularly those which cause harm to third parties or interfere with legal proceedings, under Rule 3.4c, often result in term suspensions. For example, the court in matter of Ring imposed a 3-month suspension for, among other things, repeatedly disobeying court orders in his own divorce action, and 7 adjudications of contempt mitigated by depression. Comparatively, in matter of Johnson, the respondent was disbarred for multiple disciplinary violations, including engaging in knowing violations of juvenile court standing orders. And as shown in the matter of Kirker, resulting in a 1 year and a day suspension, and matter of Cobb, which, among other factors, resulted in disbarment, as detailed in the hearing committee's report, term suspension is also appropriate in situations where a respondent violates Rule 8.2 by making statements without supporting evidence or an objectively reasonable basis concerning the integrity of judges with reckless disregard as to their truth or falsity. Given this precedent, as well as multiple rule violations and several factors in aggravation, conduct merited at least a 2-year suspension. The hearing committee agreed and recommended 2 years with conditions including reinstatement. On review of the record, Bar Counsel requests the board affirm the hearing committee's decision and adopt its recommendation. Thank you for your participation on this board and in resolving this matter.
Thank you. This concludes the oral argument in this matter.
May I have a rebuttal,
The-
please?
No, ma'am, there is no rebuttal. The hearing is now concluded.
Except the fact that this doesn't involve a
and the,
juvenile hearing,
camera
and it's
should
not
now
a
be turned
divorce.
off. The hearing is